Good morning. This way. I'm gonna have you step in the middle. All right. All right, everyone, we're going on the record. Please keep it down. All right, we're going on the record in two cases. Both gentlemen, I have first here Cameron Covarrubias, cause number 252-8573, and also Mr. Jonah Dowdy, cause number 253-1937. Today is October 14th. It's approximately 10:31 in the morning. I need you guys to please announce yourselves for purposes of the record.
George Lindsay for the state of Texas, bar number 240-99050.
John Paul Cedillo for the defendants, Judge.
And we are here now so that we can memorialize a couple of things before going forward. Both gentlemen are currently in custody. Both gentlemen are in custody because they have both felony cases in which they have not made a bond. Specifically, Mr. Covarrubias, you are charged with endangering a child and you have not made bond on that case. And Mr. Dowdy, you have been charged with aggravated kidnapping, and on that case, you have not made bond either. That said, they have made bond in both of our cases here, so the felony cases are what's holding them in custody now. I've been made aware by defense counsel, Mr. Cedillo, that these cases are very early. Both have been filed about the September, well, Mr. Covarrubias' case was filed September 10th, and Mr. Dowdy's on October 1st. So they're very, very early in their existence. Specifically, Mr. Covarrubias' case is only 35 days old, and Mr. Dowdy's is only 13 days old. And Mr. Cedillo now would like to set these cases for trial, and he's filing speedy trial motions so that we can get the case to trial fast.
Already filed, Judge.
To obtain a resolution pretty quick. However, that being said, the case is only 13 days and 35 days respectively. So as a result, not all the discovery is in. So I guess let me start out. You filed your speedy trial motions.
Yes, Judge.
What do you want?
Judge, as per my client's rights under the U.S. and Texas Constitution, we just want the closest trial date that the court has on its calendar. I think Your Honor indicated that before the next year, December, first week of December is available. So that's what we're asking. The prosecution has asked us to waive some of my client's rights. We will certainly waive some of the deadline rights, but prosecution is under the continuing obligation to supplement any discovery, which I don't doubt they will. And any extraneous notices, things of that nature, Judge, I don't think that we should, by asserting my client's speedy trial rights, I don't think I should waive their other rights away. I think they have a right to notice of any extraneous or any other evidence of that nature prior to trial. So I would push back against that, but we will waive any business record filing deadlines, anything like that prior to trial, because we do want my clients to get their day in court as soon as possible.
What rights are you specifically asking to be waived?
So Judge, these cases are fairly new. You have one case that's about 15 days old, another case is close to thereabouts, about 30. Both these defendants have made bond on their misdemeanor cases. The fact they're being held on a felony bond, though, is crucial. As far as the misdemeanor goes, they have made bond in those cases. The state would ask that, given the defense's absolute right to jury trial, and making a motion towards speedy trial first, the state would ask, one, from the court to give the state enough time in order to preserve the defendant's right to discovery and any potentially exculpatory information in order to protect the defendants. Therefore, the state would ask for as long as the trial setting as the court is willing to give. Two, in addition to, the state would ask the defense to waive any notices of business record affidavits, if so, the state, after practicing due diligence, comes into possession of said records up to, near, and including on the day of trial. Additionally, if any new evidence is developed, the state will make every diligent effort to turn over that evidence as expeditiously as possible. But given how quick turnaround these cases are, and due to the limitations of the technology that we have before us, we will make every advantage we can, but we would ask that any type of trial notice the defense has a right to be waived. And that the defense is made aware that that could include potentially exculpatory information that the state will make every diligent effort to give and provide to the defense, even including and even past trial, as is our obligation with the state of Texas under law. But so that the defendants are fully aware that going to trial without having all the evidence does not benefit the defendants in any scope, and we want them to make a knowledgeable and a voluntary waiver of any type of notice requirements they may have to discovery that would prevent normally the state being able to provide evidence in the trial.
Judge, can I just give Your Honor some quick context? These are both evading cases. As Your Honor knows, those are essentially just sort of video. One of Mr. Cameron's case, we already have the video of. So, I mean, that's sort of the crux of both of these guys' cases in these types of cases. So we're not going to be waiting on any, custody, like lab documents.
DNA or
no, Your Honor.
ballistics.
Exactly. So they're evading their dash and body cam, one of which I already have. The other one, from practicing here, they come fairly quickly. I think in November, first week in November date, Judge, should be sufficient. And I will agree to waive any business records.
That's literally, that's not even a month to get them ready for trial.
But right, Judge, but they're essentially video cases, Judge. And one of them we already have. So, it's a month, 5 weeks. And if opposing counsel needs more time or needs some issue, I think we can revisit it. But
I want to be as fair to you as I can, but I also have to be fair to the state, right? It's only 13 to 15 days old. I mean, I can't imagine they have anything now to set a date for trial for 2 to 3 weeks. I think that would be, really pushing it. I think that December is a really a lot. It's a better date for sure to give them enough time and not have them freak out with just, okay, we got to get out, drop everything. And remember, they have thousands of other cases as well. Mr. Lindsay, what do you think about it this first week in December?
I think it's fine, Judge. Also, we'd like to communicate and offer a time served for both these individuals. They like to plead on today and get them out of your court. That way they can just be freed up to look at their felonies.
Okay.
Because general practices, once we set for trial, Judge, I mean, the state's gonna be busy trying to get discovery, and then we may not be guaranteed to any type of offer. I don't want to be beholden to an offer that I make today, kind of under the gun, no pun intended. So I'm willing to make a time served offer on the cases today. But I don't want to be beholden to that offer after today, because as counsel knows, as we get more discovery, the cases generally get stronger, not weaker. And I would like to highlight that he doesn't have all the videos. We don't have all the videos yet.
Right.
But I'm willing to make a time served offer today in order to get this case off the dock. But that would be only for today.
I'll let them know.
Giving you that offer, time served, meaning that you've done with these cases today, you don't need to make any kind of an agreement now. I talked to Mr. CDO, tell me what you guys want to do. It is very early, so if you guys want to set this cases for trial, we can. So is December first week, is that
Yes,
okay?
Judge, we refer to the court, as you know, speedy trial motion. I just have to ask for a trial date. I think the date is certainly up to the court's discretion, but I'm securing their rights by just asking for a date.
So let's do the first week in December, and now for purposes of of the record, you are waiving notice as far as business records.
Yes, Judge.
Anything else? Other
Potential experts,
waivers?
Judge?
That's fine, Judge. The only one, like I mentioned, that I would push back on is I think if we go to trial, there's enough time for the records are already, these folks.
Notice of
already known.
extraneous.
Extraneous is, I think, it's fair to ask for, seeing as the state right now already has, their
What do you
records.
think of that?
I think the best people who know their extraneouses are probably standing before you, Judge. They're probably pretty aware of what their extraneous offense are, the priors under 404Bs. Now, after evaluating the case, there could be a potential that extraneous offenses could come in. And we'll try and make that notice as reasonable as possible, which I think is the necessary requirement under the law, is reasonable notice. And we will make that notice as reasonable as it can under the time constraints that we're operating under. But I would like to caveat that if there was out of state, out of county judgments that the state needs to seek, to include fingerprint experts in order to prove up past judgments, those are kind of what I was leaning towards as far as notices, i.e. business record for jail cards or judgments or
Remember, that would
fingerprint
take-
experts coming in.
Oh,
I know.
That the state may not be able to provide a CV in enough time for the defense to be able to review or then rebut or get their own expert.
I'll waive any deadlines for business records for those purposes. We just want notice of if we're going to trial that they want to put on certain convictions. That's all, notice.
okay,
We'll waive the deadlines for business records and all that.
I think we're good. We okay?
Sure.
Okay, so just first Tuesday in December, we'll set both of their cases. They'll be preferentially set because they're jail cases, and then we'll go from there.
Thank you, Judge. And I'll speak to both of them about the offer the state just made.
Good luck, guys. Thanks.
Thank you.
All right. Off the record. Got one.
No, Judge, the other one's cooking. We're
No,
working
but
on,
Mr. Dowdy's pleading?
yes.
Okay. All right, good morning, Mr. Dowdy. You're back again. So you don't want to set the case for trial against? Shh. You don't want to set the case for trial against? Okay. And then Mr. Johnson, looks like you've worked out an agreement as well. Both of you guys are charged with criminal offenses. Both of you guys have agreed to plea bargain agreements. What that means is that both of these charges will go on your record. They will be there for the rest of your life. You need to understand that depending on what kind of charge you have, it may be an enhanceable offense. Mr. Dowdy, you're charged with evading arrest. You're pleading guilty to this evading arrest. It's going to go on your record. If you ever run from authorities again, you will now be charged with a felony. You're looking at a felony offense instead of a misdemeanor. Do you understand?
Yes, sir.
You will be looking at years instead of days. Do you understand? Now, Mr. Johnson, you are charged with theft. You're facing up to 6 months, both of you are facing up to a year in jail and or a $4,000 fine. Mr. Johnson, you need to understand that your case is also an enhanceable offense.
Judge, if I could, before we continue the colloquy for Mr. Johnson, he's been in jail since June 17th, Judge, but on felony MAG, motion to adjudicate. I'm just, before we go forward, will Your Honor give him
Mr.
credit?
Brea?
Yes, Judge.
I don't see.
Right, because in this court, he's only got credit for, I think, a handful of days.
Oh, you want credit?
I'm asking the court will give him credit for the time he's been in custody, which is since June.
You know, I don't know if I can, if there was a hold place.
I think that's probably not the case because he had a bond here. I think we can confirm he's been in jail for
Has
3
he been in
months.
jail that whole time? And how much credit does he have there? Uh, Okay, so we can do 60 credit for 60 then. State, are you okay with that? Mr. Lindsay,
I'm sorry, Judge. What's that?
I need to make sure that you're okay with this too. So Mr. Johnson here is pleading to the theft case. He's been on bond in our case since he's been in custody, but he's been in custody for a long time, over 100.
Credit?
Correct, are you okay?
Yes, no objection, Judge.
Okay, all right, so it's 60 days in jail, credit for the 60 days. Like I said, this is an enhanceable offense. If you continue to pick up self or theft cases, they will hit you with a felony as well, and then you were looking at days instead of years as well. Do you understand?
Sure.
Mr. Dowdy, you are being offered 10 days in jail, credit for the 13 days that you've done. Is that how you understand it? Both of you guys are giving up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not citizens, there are immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will stay on your record forever. It's even there after you die. So be careful. You understand?
Sure. How
do you plead to the evading? How do you plead to the theft? I will find both of you guys guilty, send you guys to the agreements, and good luck to you guys. Okay? Thank you, Mr. Celia. Wait, do I know you?
One.
Estoy viendo dos casos, solo uno, solo
So you're wanted for attempted murder out of Colorado.
Mira, usted
It makes a big difference. Are you waiving formal extradition?
anunciando a extradición formal usted, señor. Le dije que solo mire el juez, no me mire a mí. Escuche las instrucciones que yo le doy.
You're fine.
Está bien.
All we are doing
Lo
here
único que estamos haciendo
is
aquí
establishing identity.
es
We just want to make sure you are Willie Perroso Gutierrez. That's here, all we fight is extradition and whether you are this person. If you are, we will get you back to Colorado, and it's at that time you can fight the charges.
Se va a pelear.
We just need to make sure that you are this person. You understand?
¿Sí, señor? Tiene que hablar. Hable con la boca. Sí, señor o no, señor.
señor.
Yes,
All
sir.
right, so you're waiving them, right?
¿Está renunciando a extradición?
Sí.
Yes.
We wish you the best of luck,
Deseamos la mejor de la suerte, señor.
and we will get you back to Colorado.
Vamos a regresar a Colorado.
Cuidado, ¿no? Buena suerte.
Sigue el oficial.
Por favor, ahí,
We're just waiting on.
She was supposed to submit a protest October 7th, but I don't see that she reported to the trial.
That's an issue.
That's why I was bringing that up. I
That's
thought we
okay.
took, I thought
Nope.
you still want her to.
Yeah.
Okay. So then,
Now we got to bring her in because she's not taking the test.
looks like she missed one on 10/7.
So you want to put her on for Friday?
Sure, it was around Friday then. I'll let her know she needs to come. All right, sounds good,
All right.
Judge. Thank you.
You want to do your plea?
Yes, sir.
Wait a second. Make sure that they're ready because has he signed anything?
He signed it and fingerprinted.
Good morning. Good afternoon, Your Honor.
Your wish has been granted.
Thank you.
Now, I mean, I'm assuming, are you doing the time served?
I'm under the impression that if I waive my rights, that I'll get time served for 3 days, actually, I've been here 12, and that I'll be released today.
Is this what you want to do?
Yes, sir.
You need to understand that this charge is going to, it will go on your record. From now on, you're facing a minimum of 30 days in jail.
Yes, sir.
You got to be careful. You're also on notice now that you probably can't go back to this Greyhound. If you go back to this Greyhound, probably gonna try to arrest you again, so you got to be careful. Understand? You give up a lot of rights by entering the agreement. You give up the right to a trial, right to compel witnesses. Is this a plea as well?
Yes.
Who is this?
He was actually, but he seemed no.
James, is this your plea?
Yes, Judge.
Come on up. Let's do it all together. Just right next to him. Okay. Don't worry. Nothing bad's gonna happen. You have nothing to worry about.
Okay.
Okay. Gentlemen, both of you guys are entering into agreements now that you're going to end up pleading guilty to whatever you're charged with. It will, both of you guys go on your record. What are you charged with? You, my friend, have an enhanceable offense. You are charged with theft. You're facing up to a year in jail and or a $4,000 fine. You need to understand that if you continue to pick up theft cases, you could be potentially looking at a felony offense because they can use them to enhance. Do you understand? Now, yours is not an enhanceable offense, so you could pick up 25 of these and it'll still be the same thing, but don't.
Yes, Your Honor.
But you'll go back to jail and now you'll be facing, both of you guys will be facing at least a minimum of 30 days in jail. Both of you guys give up a lot of rights by entering into the agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you guys are not citizens, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It's not like Target, you can return it. Once you plead guilty, it will go on your record and it will be there forever. Do you understand?
Yes, Your Honor.
Is this what you want to do?
I'm under the impression that if I waive those rights, I will today. If those are conditions of the agreement, I do great.
This is correct.
I do waive my rights.
You
Your
are
Honor.
pleading to 6 days in jail. We give you credit for the time that you've done, which is 3. So
Thank you, Your
you're
Honor.
out today.
Thank you, Your Honor.
Mr. Wingham, you were charged with like the theft, you're 10 days in jail, credit for the 18 days that you've done. This is how you understand it. How do you plead to the theft, sir? I will find you guilty. Follow the agreement on both of you guys and good luck. Good luck.
Thank you, sir.
All right.
Have a nice day.
Have a great trip back.